The day my brother walked out of that conference room with a signed copy of our father's business, he looked at me like he'd just won something. He had. That was the point. My attorney grabbed my arm in the hallway. "You realize what you just did," she said. Not a question. More like a warning she was too late to give. "I do," I said. She didn't believe me. Nobody did. That was fine. My father built Alderton Mechanical over 30 years, started it in a garage on Fenwick Road with 2 employees and a used truck. By the time I was in high school, it had 12 service vans, a dispatch team, and a commercial contract with 3 school districts. He loved that business the way some men love their children. Maybe more than, if I'm honest. He died in February 2 years ago. Heart attack. No warning, no goodbye, no time to explain what he wanted done with any of it. My brother and I were the only heirs. Our mother had passed when we were young. There was a will, but it was vague in the way that wills written by stubborn men, who believe they'll live forever, tend to be vague. The business was split between us, 60% to me, 40% to my brother. But there was no operating agreement, no succession plan, no instruction on what happened if we disagreed. We disagreed immediately. My brother wanted to sell. I wanted to keep it running. I had been doing the books for Alderton since I was 19. I knew the vendors, the clients, the renewal schedules. My father had been teaching me in his way for years. My brother had spent most of that time living in Phoenix working in real estate. He knew the logo on the truck. That was about it. "It's not about sentiment," he told me at the kitchen table the week after the funeral. "The offer on the table is solid. We take it, split it, done." "There's no offer on the table," I said. "There will be. I've already made some calls." I stared at him. Our father's body had been in the ground for 9 days. I told him I wasn't selling. He told me I didn't have the votes. I told him 60 beats 40 every time. He told me he'd get a lawyer. He did. For 8 months we were in mediation. His attorney was aggressive in that particular way that signals someone is billing by the hour and enjoying it. Every meeting ended with a new demand. Every agreement we reached fell apart when his side added conditions overnight. My own attorney, a woman named Vera who had been practicing business law in this city since before I was born, kept telling me to hold the line. He can't force a sale without a court order, and a court order takes time and money he doesn't have. She was right about the court order. She was wrong about the money. Turns out my brother had taken a second mortgage on his house in Phoenix and retained one of the largest business litigation firms in the state. I found that out on a Tuesday morning when I was served papers at my front door. He was suing for forced dissolution of the partnership and a court-ordered buyout. I sat on my front step for a while. The mail carrier walked by and said good morning. I said it back. I watched a dog sniff a fire hydrant across the street. Normal world, doing normal things, while mine was cracking open. Then I went inside and called Vera. "He might have a case," she told me on the phone. That was not what I wanted to hear. "Explain." "Minority partners in certain states have dissolution rights when a majority partner takes actions that effectively freeze them out of management. Have you been consulting him on decisions?" I had not been consulting him on decisions. I had been running the business the way I'd always run it, the way my father had taught me, because that was the only way I knew how to keep it alive. "We need to fight this," Vera said. "Full discovery, depose the brother, counter-sue for breach of fiduciary duty. How long does that take? 2 years, maybe 3. And he has a firm that knows how to drag things out." I asked what it would cost. She told me. I did the math on what Alderton was earning, and I sat with that number for a long time. That night, I didn't sleep. I went through the company files instead. The contracts, the equipment leases, the service agreements. I was looking for something. I wasn't sure what yet. Just looking. I found it at 2 a.m. When my father set up the business, he had taken on a small business loan from the county economic development program. It was from a long time ago, largely forgiven, but the original loan agreement had a clause that I'd seen 100 times without ever really reading. It said that in the event of ownership transfer, voluntary or court-ordered, the new owner was required to assume full liability for any outstanding compliance obligations connected to the original loan. Those obligations included environmental inspection requirements on the shop property, an ADA accessibility update that had been deferred twice, and this was the part that made me sit up straight, a workforce maintenance provision requiring the business to retain at least 8 of its original employees for a period of 5 years from the date of transfer or face a clawback of the original loan value plus interest. My father had been granted an exemption during the pandemic. The clock had reset. There were 4 years left on the 5-year window. That wasn't all. The commercial contracts with the school districts each contained a clause I'd negotiated myself, 2 years before my father died. It said that, in the event of a change in majority ownership, the districts retained the right to renegotiate or terminate with 90 days' notice. I'd put it in at their request. I hadn't thought about it in years. My brother's attorney was trying to force a transfer of my 60% stake. If that transfer happened, voluntarily or by court order, those school district contracts, which were nearly 40% of annual revenue, could walk out the door in 90 days, and the compliance obligations from the old loan would attach immediately to whoever held ownership. My brother didn't know any of this. His attorney, I suspected, hadn't read anything past the partnership split. I closed the laptop. I sat in the dark for a while. Then I thought about something Vera had said weeks earlier, almost in passing. She'd said, sometimes the smartest move is the one that looks like surrender. I called Vera the next morning and told her I wanted to explore settlement. She was quiet for a moment. What kind of settlement? I want to give him what he's asking for. Another silence. Longer this time. Walk me through your thinking, she said carefully. I walked her through it. All of it. The loan clause, the workforce provision, the school district contracts. She listened without interrupting, which was unusual for Vera. When I finished, she said nothing for a full 10 seconds. Then, you want to let him take the business. I want to offer him a buyout of my 60% stake at fair market value. Let him assume full ownership. And let his attorney draft the transfer documents. And you think his attorney won't catch the obligations? I think his attorney has been focused entirely on the partnership dispute and the valuation question. I don't think he's read the underlying contracts. I don't think he's pulled the original loan documents. Why would he? He was hired to win a dissolution fight, not to do due diligence on an acquisition. Vera made a sound I hadn't heard from her before. It might have been admiration. It might have been concern. Probably both. If this goes wrong, she said, you walk away with cash and he gets a business that's about to bleed out. That's correct. And if the school districts don't invoke their clause and the compliance costs aren't as bad as you think, then he has a functioning business and I have cash and a clean exit. Either way, I'm out. She was quiet again. Then, what do you want me to do? Be in that room when I make the offer. Let me do the talking. Don't volunteer anything. She agreed. I could tell she thought I was either very smart or about to make a catastrophic mistake. Maybe both. I didn't blame her. The settlement meeting was on a Thursday in a conference room on the 14th floor of a building downtown. My brother was there with his 2 attorneys. I came with Vera. My brother looked satisfied before I even sat down. He'd been in litigation mode for 8 months. Tense, combative, always pushing. Seeing me walk in with a settlement posture seemed to relax him in a way that told me everything about how he'd understood this fight. He thought he'd worn me down. I let him think that. I made the offer cleanly. Fair market valuation on my 60%, calculated by a third-party assessor we'd agreed on months earlier. He would assume full ownership of Alderton Mechanical, all assets, all liabilities, all obligations, all existing contracts. A clean transfer. His lead attorney leaned over and whispered something to him. My brother nodded. We'll take it, he said. I nodded. Vera slid the draft agreement across the table. What happened next took about 40 minutes. His attorneys reviewed the draft. They pushed back on 2 terms. Both minor, both unrelated to what I was watching for. We conceded both. They seemed pleased with that. My brother signed. I signed. Hands were shaken. In the hallway, my brother said, I didn't think you'd fold. I said, I got tired. He laughed a little. It wasn't unkind. We'd been close once, a long time ago before our father got sick and the money question started sitting between us. I felt something when he laughed. Not warmth exactly, but the memory of warmth. Then the elevator came and he was gone. I won't pretend I felt good in the days that followed. I felt strange. Like someone who'd set down a weight they'd been carrying so long they'd forgotten what their hands felt like. Empty. I went back to work, my regular job, a project management role I'd kept through all of this, and I tried to think about something else. Some days I managed it. 31 days after the transfer, I got a call from Vera. His attorney called me this morning, she said. I waited. The school district set notice, both of them. 90-day renegotiation window, effective immediately. I sat down. Combined, those contracts are. I know what they are, I said. His attorney is claiming the transfer documents didn't include adequate disclosure of the contract clauses. The contracts were listed in the asset schedule. Appendix C. Every one of them. I know. I drafted that schedule personally. There was a pause. He's also asking about the loan compliance obligations. The workforce provision. Apparently they got a notice from the county this week about the deferred ADA update. Estimated cost is somewhere between $60,000 and $90,000. And the 5-year workforce clock. He had to let go of 2 people last month for performance reasons. He's now under the threshold. I didn't say anything. He wants to talk, Vera said. His attorney called it a good faith conversation about shared obligations. I almost laughed. Shared obligations. He'd taken the business. He'd signed the documents. He'd shaken my hand. Tell them I'm available Friday, I said. That Friday meeting was different from the Thursday one 8 months earlier. My brother came in without the big litigation firm, just his original attorney, a younger guy who looked like he hadn't slept well in a while. My brother himself was quieter. The satisfaction from the conference room was gone. His attorney laid it out carefully. The school district notices, the compliance costs, the workforce clause. He framed it as a disclosure issue, suggested that I had an ongoing obligation to have flagged these risks more explicitly at the time of transfer. Vera set a copy of the signed asset schedule on the table. Appendix C, 3 pages of contracts, each one listed with its title, parties, and date, including the school district agreements and their change of ownership provisions, which were described in plain language in the contract summaries my father's administrative assistant had compiled years ago. Everything was disclosed, Vera said simply. Every obligation, every contract, every clause. If there was a failure to read and understand the documents before signing, that failure is not on my client. My brother looked at the pages. Then he looked at me. You knew, he said. It wasn't an accusation. It was just a fact. I knew what was in the documents I'd been managing for years, I said. Yes, you let me take it anyway. I looked at him. You sued me for it. You spent 8 months and a second mortgage trying to force me to give it up. I gave it up. He was quiet. I didn't hide anything, I said. I handed you every document. I handed you the keys. What happened after that is ownership. His attorney started to say something about equitable disclosure standards. Vera interrupted him, gently but clearly, with a case citation I didn't recognize. They went back and forth for a while. I let them. What I was thinking about was my father, the way he used to say that the most important thing in business wasn't the product or the clients, or even the people. It was the paperwork. The paperwork tells the truth, he'd say. People lie. Contracts don't. He'd been trying to teach me something for 30 years. I'd finally learned it. There was no second lawsuit. His attorney, to his credit, was honest with my brother about where things stood. The obligations were real, the disclosure had been made, and the courts were not going to unwind a clean transfer because the acquiring party hadn't done thorough due diligence. The school districts did invoke the clause. One renegotiated to a lower contract value. The other walked. My brother spent the next 6 months cutting costs, renegotiating vendor terms, and navigating the compliance work. He retained enough employees to avoid the loan clawback, barely. Alderton Mechanical survived. Smaller than before. Leaner. He's still running it, as far as I know. He called me once, about 4 months after that Friday meeting. Not to argue. Just to talk. He asked how I was doing. I told him. He told me things were hard, but manageable. I said I was glad to hear it. He asked if I'd known all along that this was how it would play out. I told him honestly, I hadn't known. I'd hoped. I'd read the documents and I'd made a decision based on what I found. But I hadn't known. "You're like Dad," he said. Not meanly. I didn't know what to say to that, so I just said, "Thank you." What I took from all of it. The months of fighting, the sleepless nights, the 2 a.m. discovery that changed everything, was something I keep coming back to. My brother and I were fighting over my father's business. We thought we were fighting over money, or control, or who Dad loved more, or some old score that neither of us could quite name. But what we were really fighting over was paper, documents, agreements made in good faith between people who trusted each other. My father and the county, my father and the school districts, my father and his employees. My father believed that taking care of a thing meant understanding what it cost, not just in dollars, in time, in obligation, in the weight of having your name on something. He'd spent 30 years building Alderton. He'd known every clause in every contract. He'd shown up for every compliance review, every renewal conversation, every hard conversation with a client who wanted to walk. My brother thought he was taking the business. He was. But he was also taking everything that came with it. Ownership isn't just the asset, it's the obligation. It's every promise your predecessor made that now has your name on it. It's the calls you get on Friday mornings from the county. It's the employees whose jobs depend on a clause in a loan agreement from 20 years ago. My father knew that. He lived it. I learned it at a conference table on a Thursday afternoon, watching my brother sign his name on the line. I didn't feel like I won. I felt like I finally understood the lesson my father had been teaching me the whole time. That was enough. I've thought a lot about what my father was actually trying to hand me. All those years he had me sitting beside him at the desk going through contracts. At the time, I thought it was just work. Learn the business, know the numbers, understand the schedules. I didn't realize he was teaching me something quieter than that. He was teaching me that the things we fight hardest for are rarely the things we think they are. We think we're fighting for the asset, the building, the trucks, the name on the side of the van, but the asset is just the surface. Underneath it is everything the previous owner promised, every obligation they signed their name to, every consequence they agreed to carry. My brother thought he was fighting for Alderton. He spent 8 months and a second mortgage trying to take it. He got it. And then he discovered that getting it meant getting all of it. The deferred compliance work, the workforce clause, the school district contracts with their 90-day exit windows. He'd won exactly what he asked for. That's not irony. That's just cause and effect working the way it always does, quietly and without apology. I don't think my brother is a bad person. I want to be honest about that. He was grieving, and he was scared, and he made the mistake a lot of people make when they're both of those things at once. He reached for control. He thought that if he could just get the business, get his name on it, get his share of what Dad built, then something would settle. Some old ache would ease. I understood that feeling. I had it too. The difference was that I'd spent years inside those documents. I knew what ownership actually looked like from the inside. He knew what it looked like from the outside, and those are two completely different things. What carried me through the hardest part of all of it? The sleepless nights, the mediation rooms, the morning I got served on my own front step, wasn't anger. It was something steadier than that. It was the discipline my father had built into me without either of us ever naming it. The habit of reading carefully. The patience to sit with a document at 2 a.m. and not stop until you understand what it's actually saying. The willingness to make a decision that looks like weakness because you understand something the other side doesn't. That's not cleverness. Cleverness is a trick. What I'm describing is something you build over time, through repetition, through showing up for the unglamorous parts of a thing. The paperwork, the renewals, the compliance calls nobody wants to make. My father showed up for all of it for 30 years. He didn't do it because it was exciting. He did it because he understood that integrity and knowledge aren't separate things. Knowing what you've committed to and honoring it, that's a single act, not two. My brother called me eventually, not to argue, just to talk. That mattered to me more than the outcome of any document. We're not close the way we were when we were young, but we're not broken either. That feels like the thing worth keeping. I didn't walk away from this with the business. I walked away with the cash from a fair buyout, a clean exit, and the understanding that what my father left me wasn't really Alderton mechanical. It was 30 years of watching him do things the right way. That doesn't show up in any asset schedule, but it was the most valuable thing in the room.